This is Brian Burke with the law firm of Sam Shihab and Associates. And we're going to talk to you today about a couple of interesting topics. First of all, we're going to get an update on the reconciliation bill, where it stands. Obviously, we were expecting last-minute shifts and changes. The good news is still alive, but we are going to update you on it. And we're going to go through a very interesting topic that a lot of people ask about is, what are my options under my adjustment of status filing? What can I and can I not do under adjustment of status? Without further delay, Brian, can you give us a quick update on the what's going on with Congress?
Yeah, so last Thursday we were hoping for a vote, and Congress, the House, was hoping for a vote as well. And it didn't happen on Thursday, but on Friday there was a vote on the nonpartisan infrastructure bill. That's infrastructure. And that's a good thing, but what they left behind for the time being was the Build Back Better Act, which contains all the stuff that a lot of our audience is interested in. It's the recapture of visas, employment-based, family-based, and the super fee that would, allow you to jump the line for green card processing. So those aren't dead, though. Like you said, in order to do the infrastructure bill vote, they agreed that they would vote on the Build Back Better Act in the House by the 15th. And once it makes it past there, which it seems like it's going to do, it then moves on to the Senate, and that's where the real fight is.
All right. So let me kind of.
I'll come out at 1,000 miles per hour. Slow it down for me, Sam.
Let me see if I can rephrase it and clarify. So there were two bills to begin with.
Yeah.
And Nancy Pelosi was holding both bills She wants to push them at the same time.
Yeah, locked together.
And she wasn't really able to do that.
Yeah.
And therefore, she decided that to push the infrastructure bill forward first. But before she did that, she was able to get in writing from some of the representatives a commitment to support the Build Back Better Act, which is the second bill,
yes,
right?
Yes.
And that's the one that has the social safety net legislation and the immigration stuff.
Yeah.
And she's pushing it next week.
The 15th is next Monday.
Today's the 8th?
Yes, today's the 8th. That's next Monday.
Okay, so we are not there yet. We're not dead yet. Obviously, there are issues with whether or not the House the Senate parliamentarian is going to comment on it. They're trying to also include some legalization.
Yeah.
So there's a lot going on. Next week is going to be a lot. We thought it's going to be last week. Looks like it's next week. Well, welcome to Congress. Welcome to politics. But we are still alive and kicking, and it's still going, which is great news.
Yeah.
All right.
Yeah. So,
excellent summary.
Yeah.
And we're going to go with another short. Or a presentation whenever it's released.
I got to pick a new room in my house to do it from.
Living room. Or maybe I'll do it in my kitchen.
Oh.
Next time, since Brian did it in his kitchen. But look forward to next week. I think next week is going to be an interesting week for us again. Again, I repeat, it might be the single most important immigration legislation in a long time.
I fully agree with that. I mean, I've been doing this for 10 years, Sam. I don't think I've really seen in my time as an immigration lawyer a real significant piece of immigration legislation get passed. And this is something that's going to happen.
It is not out of the woodwork. It is still in danger. I mean, there are still concerns about it. There are people who are concerned about other things in the bill that's not related to immigration that's holding it back. So there's a lot to fight through to get it into a vote, and we need 50% vote on that one. Correct?
Yeah.
Yes.
So we're committing ourselves. We're having some fun doing those short little YouTube videos. So if you guys liked them, subscribe, because we're going to do more of them, and going to try to keep people updated. Say hello every now and again during the week.
Yes, and you can get the most recent updates. So we're going to do a little bit more shorts. And I like you did a great job, Brian.
Well,
don't you guys agree with me? If you guys agree with me, give Brian a subscription or a thumbs up.
Make me feel good,
because I loved it. I think you did a great job.
Well, I thought it was very good. I got it in just under 60 seconds. That's the requirement for YouTube Short. Ask me how many times it took. A lot. Is the short answer there.
You're supposed to say if I worked from the first time. That's what you're supposed to say.
Watch this. Actually, it came perfectly out of my mouth the first time. One take, I was in bed.
Okay. Funny. And we're going to be talking about options under adjustment of status. And there's what we did is we prepared a bunch of questions that we get asked all the time. As a matter of fact, there is a good friend of mine who had asked me a question, and he went back and forth with me. And the question is, if he's listening to me, because we're going to break it down, is if I file one of them, if I file, and if I file my EB3 adjustment of status, and I have an employment authorization document, EAD, and I'm still under H-1B right now, so I have not stepped out of my H-1B, and I'd like to file a second EB2 adjustment status. Can I use the EAD from the EB3, and would that affect my EB2 filing? And we're going to answer that one and others as well. So without further delay, let's throw in the first question on the screen.
Yeah.
And let's break it down.
So there's our title slide. Let's move past that. Bing. When can I file a second I-485, Sam?
Okay. Whenever you want, Brian. When can you file one and get it approved is the question.
Yeah.
Right? When can I file it and get it
approved? When
can you file? You can file anytime.
They're willing to take your money at any time.
Or send it back and send you the money. So the key requirement is the status requirement.
You have to be in status as an employment-based adjustment.
In a non-immigrant status.
In non-immigrant status.
Okay. And you have not violated your non-immigrant status, although we're going to discuss that a little bit more. Yeah. But what scenarios that are not being in a good non-immigrant status that would allow for an adjustment?
Well, you file your first adjustment of status. You're in H-1B, L1, H-4 status at the time. Good thing. And then let's say you want to use that EAD. You leave behind your non-immigrant status. You're no longer in H-1B, H-4, etc. Well, that's it. You're not in H-1B. You're not in status anymore. You can't file for a second adjustment.
Okay, so let's be very clear here for everybody. So if you filed your EB3 adjustment status, and then you commence to work on EAD under EB3, subject to some exception we're going to talk about later, you really cannot file another I-485 EB2 because you're no longer in status.
Yeah.
Now, I'm going to switch things around,
okay,
and we can just play with it a little bit, and I think it'll be informative. If your spouse worked under EAD, under her EB3 or derivative EB3 adjustment status, green card EAD, now you want to file an EB2, can you file an EB2 for her?
If
a derivative EB2 adjustment status.
So she's abandoned. Well, she
worked.
She worked.
So she's no longer on H4.
Yeah, no longer eligible to file for adjustment of status.
She's okay. So let's be clear here. There's no longer eligible to apply for one more.
Yeah.
Adjustment of status.
A second adjustment of status.
A second adjustment of status. But that is not, in my opinion, so everybody's clear, a deterrent or should not hold you back. So let's play this thing out for a second. So your EB2 priority is moving rapidly, and you got to get on that EB2. You've kept your H-1B valid. You have filed an EB3, for example. Have not, doesn't matter. Maybe you have. And your wife filed for derivative EB3, or your husband, if the principal is a female,
flip-flop, yeah.
The spouse. Now, the spouse is no longer in status, in valid non-immigrant status. You are. So you say, I got to get on that EB2, man. This is moving too quick, and I don't want to miss my green card.
Yeah.
You could file for it without filing for your spouse.
Correct.
Okay. Now, let's take it to the next level. Let's assume that your green card is approved. What is your spouse's options?
Well, is your spouse maintaining your spouse has a problem, that their non-immigrant status, if it's dependent upon you, they're toast on that front. And ultimately, what USCIS should do, what they will likely do if they approve one of your I-485s, is they will administratively close the other one. So your spouse ultimately will still be eligible for a green card, but they have to do that through consular processing abroad is the first thing that comes to mind.
Right.
Yeah.
Exactly. How can you file a spouse, if to a spouse of a permanent resident?
You can do that.
and transfer the basis.
You can.
But
your spouse has a state of,
the moment the principal's EB2 is approved, that moment, technically, it's the moment that your spouse is no longer in
I'm going to restate it because you just said a whole big complicated thing. Sam posits a scenario where where the primary person gets their green card in one category and their spouse left in the other category. Well, basically, they have no basis for their adjustment anymore. And the idea is to file a family-based green card case. That's what the F2A is for them, so they can save their pending adjustment. But the problem is, as soon as the primary applicant moves up to having a green card approved, the basis for the other adjustment, your spouse's one in the old category, disappears.
Therefore, we're back to full circle and saying that you should include your wife. It's a lot safer.
Yeah.
So if you are filing an EB2, you want to make sure that all your family members also file a second adjustment. All your family members should be filing. It's a lot safer. Otherwise, it can be risky.
Yeah.
Okay, is that a good? So when can I file a second adjustment? I have to be in status, and it is highly recommended that all your family members has to be in valid non-immigrant status.
Yeah.
Now, there's another thing that we should talk about.
Does it start with INA and end with 245K?
Good.
Okay.
So there is a 180-day grace period.
Yeah. For employment-based green card applicants only, that excuses unauthorized employment, violations of non-immigrant status, and overstay. 3 things. And that's something you have to look at very closely because that's in the aggregate since you last entered the United States. So the government, but it may be possible that if you're no longer in valid non-immigrant status to still file that second I-485. But that's something you want to look at very closely because ultimately, what's on the line? It's your government filing fees and the cost you pay to prepare the case if you have somebody helping with you. But nobody wants to get a denial.
So INA 245K allows you to do violate one of 3 conditions. Mm-hmm. Working without authorization for up to 180 days, being not in status for 180 days, and violating the terms and conditions of your current non-immigrant status for 180 days combined. So it's not 180 plus 180 plus 180. It's altogether 180 days. And if you have 2 violations in one day, it counts as 1 day.
Yeah.
Okay. So that's the rule. So if you, let's say, work without authorization, overlap your H-1Bs, or in the example, with the spouse, there's an F2A that doesn't apply for family applications, so that would not apply for the wife. So 180 days, you can file for a second adjustment. Your H-1B just ran out. 100 days later, you decide to jump on the EB2, you're not in status, ask about INA 245K, because under INA 245K, it can allow you to file a second adjustment, even though you're no longer in status, but as long as you are not in H-1B status for less than 180 days. And also, you got to look cumulatively all the way back if there are other violations. So, because they're cumulative. I hope we didn't make it too complicated.
Well, I see a good follow-up question here. I'm not going to put it on the screen, so I'm just going to try to paraphrase it, but it's a good follow-up. So in the scenario we went through, if the original petition was EB2, then EB3 gets approved. Do they have to file another EB2 45 when the EB2 dates move? So the way I interpret that question is basically, I think it's sort of, the original position was EB2. Basically, the way I understand it, is there any way? It seems to be asking if there's any way around that fact when the primary person's case gets approved. Is there any way to save the other one? Can you do it? Save with another I-45 filing? And the answer is no,
unless you're within 180 days.
Well, yeah, that's
unless you could take advantage of the 180-day INA 245K 180 days. If that's the case, you got to evaluate that option for the spouse. Ultimately, the spouse will get a green card because she can get it under something called following to join.
Yeah.
But the following join, the priority date has to be current.
Yeah. I think the point I'd underline is once the primary applicant gets their green card, they can't, new green adjustment of status applications based upon them aren't really going to be feasible, generally speaking.
Yeah. So you have EB2, you have EB3, right? I'm gonna make EB3 here. I'll make EB2 here. So EB3, and then you get derivatives. Now you file the second EB2, so I'm gonna call it 2. This is 3, right? Make it easy. So you file the second EB2, and you have derivatives below it, right? The moment this is approved, all those fail.
Yeah.
All these becomes, USCIS does not have to act on it for them to become ineffective. They kind of disappear immediately because you're a permanent resident. And if your wife under these EB3, not under the EB2, then it will be a problem for her. I keep saying the spouse, could be the other way around, where the spouse has to leave the U.S. and then finish up the green card at the consulate, which is doable, but it is an incredible inconvenience.
Yeah.
So it's nice if you want to keep it neat and clean and move everybody to the EB2 if you have a second filing. But filing alone, I think, is a bit messy and risky.
Yeah.
That would probably be a good summary.
Sam, we've only gotten through one question so far, and we wrote a ton of these.
And we burned 15 minutes.
Yeah,
we don't have to finish all of them.
Yeah, let's try to maybe hit a bit of these things more rapid fire here.
Okay.
So next question is, can I maintain my non-immigrant visa status if my dependent family members use their green card EAD?
The answer is simply yes.
Yes.
Your spouse using their green card EAD only invalidates the spouse. The spouse EAD does not even validate your children non-immigrant status.
Yeah.
Jump to the next one.
Short answer.
Yeah.
See what we got on the next one.
Can I get back on H-1B?
Put it up for everybody to see.
Can I get back on H-1B if I left my status lapse after the I-485?
Oops. Oh, boy.
After the I-485 filing?
Yes.
I'll let you do that one.
So, yes, but there's sort of a couple variations on this question. So, let's put us back on the main thing. Can I get on H-1B after I let my status lapse? So if you hand your employer your green card EAD, or you basically choose not to extend your H-1B anymore, you have let your non-immigrant status lapse. You're no longer in H-1B status. That way, so the basic rule for H-1B or any other non-immigrant status, in order to extend your stay, you have to be in valid status. So if you let your status lapse, you're not going to be able to extend or get back into it. However, if you want to do a little bit of work, it is possible. You can file a new H-1B with consular processing.
Yeah, everybody can do that.
Yeah, everybody can do that.
Everybody can leave the country and get back on H-1B.
Yeah.
Next question.
Okay, let's see what we got.
All right. What is my status when I let my non-immigrant visa lapse and use the green card EAD? You are what the law calls a period of authorized stay.
Yeah.
Okay. Pursuant to,
I believe it's the Attorney General.
The Attorney General, I think, will delegate the power to the
Department of Homeland Security.
Department of Homeland Security. So this is a period that the law allows you to stay in the United States and have some benefits, which is you're going to have work authorization benefits, advanced parole benefits, while this adjustment of status application is being considered, and that's the status. So this is not.
See, Sam,
I made a mistake. It is not a status.
Yeah.
That's the condition of your stay. How about that?
It is definitely not a status, and that's what gets my.
Yes, because status is a legal term.
Yeah.
So it is not status. It is an ability to stay in the U.S. pursuant to a permission from the Attorney General, because you have filed for an adjustment of status. And it is not advanced parole.
Yes. Segue, Sam. What's our next question?
All right. So let's put the next question on board, and then maybe once we answer a couple of them, maybe we can.
Yeah.
So what is my status when I enter the United States using my AP card, Brian?
You're a parolee.
What is a parolee?
It is somebody who they, I mean, in the context of the advanced parolee, it's somebody who they allowed to travel abroad and come back during the pendency of their adjustment status. It's basically for humanitarian reasons they allow you to travel.
And that is different set of laws than the period of stay authorized if your H-1B ran out and you were staying in the U.S.
Yes.
And there are different set of rules. And
yeah, well, so we could go into the minutia of that for a while, but what's the point I want to make? It's not status. It is not status.
It is not status. Okay, good. So you are a parolee, and how long can you become a parolee? For how long?
I cannot
For
recall.
as long as the adjustment status is pending.
Yeah.
So as long as the adjustment status is pending, you can be a parolee, and you're authorized to be in the U.S. Even if your advanced parole expired and you didn't renew it, but you're here.
You're still authorized to stay pursuant to your pending adjustment status.
You are allowed to enter as a parolee. Yeah. Okay, so that's a good one. So let's go to the next one.
Yes, what do we got? Ooh, what happens if my I-485 is denied? That's a good topic. That's a good topic, Sam. It's so good a topic, I'm going to put us back up on the big screen here.
So there's a lot of scenarios here. So my first question, to answer the question, is, am I on a non-immigrant status, or am I a parolee? Am I here a parolee? Am I here in the United States pursuant to the Attorney General?
Yeah.
Basically, my non-immigrant visa expired, or do I have a valid non-immigrant visa? So I'm going to take the easy one. I'm going to let you handle the difficult ones.
Oh, I don't want to do that, Sam.
Yes. Well, since I'm the boss,
okay,
I get to do that.
All right.
So if you are in a valid non-immigrant status, and the I-485 is denied, life is easy. Trying to figure out what's the purpose of that denial, and you can either file an appeal, or perhaps easier to file a new adjustment of status and fix it, and there's no harm done.
Yes.
Right?
Yeah.
Now, if the priority date is available when it is denied, refiling a new one is the easy answer. If the priority date is not available, definitely appealing the denial would be the way to go, hoping that you have an appealable basis. So that's if you have a valid H-1B and there's no impact on you. Obviously, if you have a valid H-1B, but you are on EAD, you're working on EAD, you're no longer on H-1B, then that is the part that Brian's going to answer, which is
you have a tough time.
Yes.
So my first high level response is there's a reasonable chance you're going to have to leave the United States. You don't have a pending adjustment to keep you authorized period of stay. You don't have a non-immigrant status. What's keeping you here?
Okay, good. So my question to you is this: if that's the case, wouldn't appealing allow you to stay in the U.S.? And what are the
the appeal itself doesn't allow you to stay in the United States. You have that just by filing it. You have to have that appeal, a motion to reopen. It would be because there's no appeal on denial of adjustment of status.
Yes.
You'd be filing a motion to reopen, and you'd have a lot of things hanging over your head. You'd have the 180 day / 1 year bar hanging over your head, worrying. I know I'm accruing unlawful presence at this point. What's gonna happen? Do I want to get that?
So first of all, you got a denial. You're not on H-1B, and then you go to your attorney and say, "What are my options?" The first thing I do is I need to look at the basis for the denial, and to see if a motion to reconsider is a viable option.
Sure.
Right. Because if it's a long shot, you need to know that. If it's a viable option, for example, they said the signature wasn't there, and clearly the signature is there, they made a mistake. If they said, well, your birth certificate, we send you an RFE, didn't respond, there was no RFE, there are things that you can definitely challenge and trying to get this case reinstated. Now, if the basis is reasonable and you have a decent chance, then you may decide to take a risk and file a motion to reconsider and stay in the U.S., although you're accruing unlawful presence, because if the motion is granted, then the case is reinstated automatically, and there is no unlawful presence, all wipes out.
Yeah.
But if it's a long shot appeal,
well, what my brain goes to you still may be eligible for a green card. It just might be a case of consular processing of that green card.
Correct.
Yeah.
That means you were not filing a motion, and you have to leave the country and then pursue
Do the green card
options.
through the consulate. Yeah.
Now, I don't know. Do you have a separate question on dual 485s?
I think we have a second. Yeah, we have a second question on two I-485s, and here it comes for everybody. Oops, wrong button. There we are. What happens if I have two I-485s and one of them is denied?
Life is good, right?
You and I have a different definition of goodness in life.
Well, am I here in the U.S.? Can I stay legally in the U.S.?
This is true. This is a good point. Yeah.
Compared to one adjustment denial?
Yeah.
Then life. Then I live. I survive today.
Yeah.
Explain it, Brian.
Well, I begin to, as soon as I hear about denied I-4, I got to say, in most employment-based I-485s, they go through. If you're being a conscientious person, you're maintaining your non-immigrant status, you have a good employer behind you, most cases are successful. But I get concerned when I hear about a denied I-45, especially for an employment-based person, because it's rare. And I wonder, I want to immediately see the grounds for denial of the first one to figure out if it's going to impact the second one.
Hold on a second.
Yes.
You're answering part B.
Am I?
Yes. Part A is, first of all, if one is denied, pursuant to the other one, you continue to stay legally in the United States.
You have that,
and you're not accruing unlawful presence.
Correct. You have that second case. You're good. You're good to stay.
Okay,
you are feeling good for that reason. But I'm an immigration attorney, Sam. I have to worry.
Well, you do, as you should. But for our viewers, so they understand that you are entitled to continue to stay in the U.S. pursuant to the other adjustment, and if they haven't taken action, even if, as Brian will be explaining to you, that both are deniable, but one is denied, one is not deniable. Let's assume there's a deficiency. Mm-hmm. There are the same deficiency in both of them, but one is denied, the other one is not denied. Today, you're here.
Yeah.
Today, you're here.
Yep.
All right. Now, back to further elaboration. You're saying that if you're worried, you would be worried about the fact that why it was denied, and I'm worried about that they both have the same deniable.
Yeah, hypothetically, let's say they find 181 days of unauthorized employment in your work history. You've gone beyond the INA 245K limits, okay. And then if that applies to one case, it's probably going to apply to the other case. And basically, all that you have, to hang your hat upon is the fact that they haven't gotten to the second case yet.
So what happened if they found 181 days?
So they're going to probably issue an RFE or annoyed.
So the second one is not denied yet. Maybe the party date is retrogressed. Mm-hmm. So it's not going to be considered for many years, right? Now, let's say you go to consular processing, you're unlawful presence, right? You have accrued unlawful presence. May not. It doesn't necessarily mean you accrued unlawful presence, because unlawful presence it's a completely different law, and we don't want to get into the details of unlawful presence right now.
Well, that's a very fun question, though. I'd love to have to argue that to the consulate.
You could easily.
I could argue. Yeah,
so you could pursue the denied one with consular processing. As long as the other I-485 is not denied yet, you can continue to stay here.
I got to illustrate this example for the people. So how can you have, so the classic example is you're approved on H-1B status, and you have a good I-94, valid I-94, but they find at the same time somebody was working for another employer for that. You'd be invalid. You'd have a valid I-94. You're not accruing unlawful presence, but you're in violation of your status, and that's not accruing unlawful presence.
So working for a different employer, right?
Yeah.
Or working out of unapproved site. There's no LCA to cover the work location. Yeah. So you violated the term and conditions of your non-work visa. So that is 180 days, part of the 180 days. So let's say they found 300 days. Yeah. Okay. You're working in New Jersey, but you're supposed to be in California, and you don't have an LCA to cover it up, and boom. INA 245K case is denied over 180 days
of unauthorized employment,
and the second adjustment status probably will be denied, but the priority date has retrogressed and nobody's looking at it. Yeah. And you have EAD, and you have advanced parole, and everything is good, right?
You're a happy camper, yeah.
Right?
More or less.
Now, there's ethical question as to whether or not you should continue here in the U.S. when you know the case is deniable. Is this case continues to be not in good faith? We're going to bypass that question for right now, because that's
a huge one. We want to do an hour on that one.
A whole week on that one. So bypassing that question, which is a very important question, but right now you're invalid adjustment status on the other one. You could start consular processing.
Yeah.
But the consular officer may be interested to know why did you continue to stay in the United States with the other
Well,
I-45.
if you got to this point, you already have counsel helping you out on this for sure. But I mean, that's a fun argument. I mean, it makes me feel a little bit better about the person who gets denied under 245K. I'm thinking, maybe you found some unauthorized work, a little bit of oopsie-doo, a little bit of side work, but I was still, I still had a valid I-94 the entire time,
Yeah. So, yep, absolutely. Wonderful. Sounds good. So, do we have that question on EB2 and EB3? I didn't see that question, Brian.
The two adjustments, two different EADs.
Yeah.
Yeah, it's all right. Yeah.
Okay. I missed it. You moved on it too quick. No. All right, go for it.
Here it is.
All right.
I keep on pushing the wrong button.
Yes, here it is.
Well, kind of the question. Which EAD AP should I use if I have them for from two I-45 cases?
And does using one invalidate the other?
Yeah.
So I have an EB3 adjustment status, and I have a complementary EAD with it. And this is I filed an EB2 adjustment status, and I did not file a complementary EAD. Now I have an EAD under the EB3, and I have an EB2 adjustment status, and I'm currently under H-1B. Now I want to take employment somewhere else, and now I want to use my EAD, right?
Yeah.
Is using the EB3 EAD invalidate the EB2 adjustment status?
No, sir.
Not in a million years. And why?
Well, having a pending green card is not a status. I guess is the short answer.
That's really the basis for it.
Yeah.
Which basically says that your adjustment status, I don't care whether EB2 or EB3, remains valid as long as you haven't violated terms and conditions of your stay in the U.S.
Yeah.
So post-adjustment status filing, what are the terms and conditions of your stay in the United States?
They're pretty darn broad. You can stay as long as your adjustment's pending. You can work as long as you have an EAD in hand.
From any source.
Anybody, yeah.
You can be on a TPS EAD. You could be on H4 EAD. Can you use H4 EAD?
Well, if you have a
probably not.
Probably not, because you have a.
Well, you can use the H4 EAD, but if you used a EB2 EAD, you cannot go back and
you've abandoned your status, and that's not a status-based EAD.
And therefore, you've abandoned the H4 EAD.
Yeah.
So you cannot do that. So that can get you in trouble.
Yeah.
They can easily get you in trouble.
So this is one that comes up a whole lot. It's basically, I'm waiting for my green card EAD. Can I use my
to renew my green card EAD? It's behind in renewal, and I have a job, but I have an H4 EAD. Can I use that? It says valid. It has the dates on it. Why can I not use it?
Yeah.
You cannot use it, and that's so unfair.
Yeah, I know, but this is one that comes up a surprising amount, and people have trouble understanding this. Though it's what are the rules of your H4 status? It's you have an H4 I-94, and you can work with an employment authorization. That employment authorization is no good without an H4 I-94. You abandon your H4 everything when you use that other EAD.
But the EB3 EAD is not a violation of the EAD because it's not a status-based EAD. It's an adjustment status-based EAD, which is perfectly valid. And therefore, if you're on EB2, you can most certainly use the EAD on EB3, and it's not an abandonment of the EB2.
Yeah, until they tell you that EB3 EAD is denied. Now, it's an interesting hypothetical we're talking about. You have two adjustment statuses, right? They deny one, and what about the you're working pursuant to that adjustment status?
You got to stop working immediately.
Yeah, assuming they notify. Yeah, they will notify you if they deny adjustment status. Very rare, but they will notify you that your EAD and AP are associated with it or toast as well.
And the easiest thing to do is file another EAD under the EB2 if you don't want to have to worry about it. And honestly, if you present one or the other between the EB2 and the EB3 EAD is absolutely the same, interchangeable.
Yeah.
Now you cannot present the EAD for the H4 because clearly you're cannot work pursuant to that. If you've worked on an EB2 or an EB3 or green card EAD.
Yeah.
So you cannot, you need probably just cut that one.
Yeah.
Throw it in the drawer so you don't use it by mistake. You don't present it. And the question is, how can you prove it? I mean, proving it is we talk theory here, but proving it is almost impossible.
I mean, what happens to form? Everybody raise your hand if you've completed the I-9. Sam, you're the boss. Do you have to complete the I-9 on day one of Sam Sheehan Associates?
I have completed my own I-9. I had my partner complete an I-9 for me.
Yeah,
which is valid until today.
Well, I've done an I-9. You've done it. Everybody out there's done an I-9. And what goes on that, the employment authorization, it's not like that gets sent off to the government somewhere. That just sits in your employer's drawer, and it's used in case ICE comes to audit them. So right. Who knows?
Right. There is a record out there, but it's so difficult to find.
Yeah.
But obviously, if you're working and the EAD expired, the EB2 or EB3 are both expired, and you have a third EAD based on H4 and you used it, well, they can find that because that period of work is outside the EAD.
Yeah,
period.
I mean, those questions come up. They occasionally issue RFEs on adjustment of status to say, hey, show us your work authorization since date X.
Yeah.
And they will do that. They were looking for, beyond 180 days, 245K violation.
Yeah, so you file an H-1B transfer, you start working, but the H-1B doesn't go through, you get sent back, and then they file another H-1B, so you've worked 1 day without authorization. They can discover those, and they can count those. But if you're less than 180 days, you continue, you get your green card. Yeah. So those are the questions that we have.
Yeah.
Do you want to elaborate on any of them, or any people have any questions?
I think we saved the coolest, most interesting one for last. And when I do things like this, it means I'm excited about it.
Tell me, which one?
The last one is they give you the my big beef as an immigration lawyer is they give people these documents and they don't the rules aren't very clear to a lot of people. I mean, I feel sorry for students who come to the United States. They just handed a visa and told go to school, and those guys aren't told how to maintain their status at all. And it's all these very particular questions, which as immigration lawyers, we have to think a whole lot to answer, and it makes it very, very easy for people to fall into massive pitfalls and screw up their status.
I had a guy that I was at a naturalization interview today. And one of the biggest, we were looking into, he's been here in the country for 20 years. One of the biggest violation he has, we're worried about that they bring it up, is that he arrived on a student visa and didn't attend school.
A popular question. I've been to a bunch of green card interviews lately. They've been asking about that.
He told me his story. He had the fees, filing fees with him to pay. But he arrived 20 days earlier, so he's allowed.
Yeah,
fine.
Yeah.
So he swung to see his brother's friend. This kid is arriving here in the U.S., has no idea what the law is, and he said, "Well, my brother, who is my sponsor, lost his job. He just lost his job." He said, "Don't worry about it. Just don't go to school this semester." He said, "Don't go to school this semester. Just go to school next semester." He goes,
ding, 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 ding.
He said, "Can I do that?" He said, "Oh yeah, you can do that. It's no big deal."
Yeah.
He told me it took me 15 years to get back on track. He got his degree. He finally got his degree. He's a business owner now and applying for citizenship 20 years after he came. He said, the biggest mistake of my life, first week I came in, I have no understanding what the law is.
Yeah.
And I just talked to somebody who said, "Oh, stay here. I'll just help you get a job in a gas station. Just work for a few months, save some money, and then go to school." And he said, "Yeah, it's a good idea." Boom. His life derailed for 15 years.
Yeah. I mean, students violations so easy. I mean, I-94 conflicts. I have 5 different I-94s. Which one's valid? Things like that. There's so many little things out there. It makes it hard for people.
I agree.
Yeah.
I agree.
Well, we went through what we wanted to talk about, Sam. And again, I think they're pretty good. So let's see what people have for us.
All right. Let's
questions.
do it.
Let's see what we got.
Throw it in.
So from Manoj K, is there any issue for green card / H-1B processing if I work from home 5 days a week and go to the office occasionally?
Well, the short answer is no. There is not a problem as long as the labor certification and the PERM labor certification can cover commuting, because a few years ago, commuting was a big deal. And it allows for commuting. Obviously, if this happened because of the pandemic and it's temporary, that's a different story.
Well, you see, you're approaching this question entirely different than me. I'm more thinking about, for a green card, I'm thinking like if I have a green card EAD or if I'm on H-1B. So if you have a green card, if you have a green card EAD, you can work, those things are unlimited. You can work whoever you want, however you want. There's no LCA requirements. When I think about H-1Bs, I'm worried about if your H-1B is in compliance, whether your home location is covered by the LCA that was, was in your office location are covered.
Well, the question says processing, all right?
Yeah.
Well, there's processing and there's compliance.
Yeah.
So clearly, I mean, both issues are relevant. So from a compliance standpoint, which you touched on it a little bit, you know, clearly, if you're working from home, hopefully you will have an LCA that cover that MSA, which is the Metropolitan Statistical Area, that covers where you live. And recently, site visitations has been focusing intensely on it. If you guys know anything about the Democrats, they love audits. They love site visitations, and recently they have been vicious.
I've been getting a lot of calls from clients, not just the site visitations they get, it's that they're worried about them as well.
The intensity of the site visitation is quite atrocious. I mean, my goodness. So now from a green card processing, clearly it is about future employment, right? And in that labor certification, there's different ways to draft these labor certifications.
That's true, yeah.
And whether it allows for telecommuting, whether it allows for work location, different location, the key is at the time of the green card approval, you have to comply with the details of that labor certification. If it says you got to work in that MSA at that office, you got to be at that office. Until then, it doesn't matter.
Yeah, and to that end, I'd say, go to the MSA. There, however, you might be able to. You have a supplement, supplement J, different if your employer's. We can go into this question forever. There's a lot of ways to interpret it, huh?
Good question, Manoj. Thank you for giving us a simple but complicated one.
Yeah. So a couple comments on the general talk of.
Well, throw in the comments. Let's hear them.
All right. Well, the audio wasn't as good as this, Brian, from your kitchen. Well, you may have noticed I didn't have a lapel mic in my kitchen. I had it done from my phone, and I had it in my kitchen cabinet up against.
I thought the audio. I think. Are you saying that the audio in the kitchen is worse than the audio here? I thought your audio was fantastic.
Oh yeah.
In my opinion.
Well, I have a fan and a detractor, but I shall try to do better. I thought it sounded pretty good. But
is the audio here better? I'd like to have it, or is the audio in the kitchen better?
Sam, we can do this live from my kitchen. My kitchen's pretty small, but
well, hey, I bet you there's cold beer next to that.
Not in my house.
No. You beer in the house.
No beer. No.
Then you're going to be having my presentation in my house.
My friends bring beer to my house, though.
Nice. All right. Okay. Good comment. All right. So.
See what we got.
There was a smiley face on that one that you skipped.
Oh, well,
no, we'll take it next.
No. In the order received, much like the Native Americans welcomed the Pilgrims in 1620, Congress is preparing a Thanksgiving gift.
I hope so. That's a fantastic comment. That's a fantastic comment, and I hope it's a gift. I am so excited about it because honestly, guys, we need a break. This cannot continue. I am tired of saying 750,000 green cards. When are we going to get through these green cards? We need to get all these green cards that were wasted back. Yeah. So that's wonderful. Yes, that'll be wonderful. That'll be great turkey this year if that happens.
Great turkey.
Yes.
Great turkey. So hi, Sam and Brian. Last time you advised me to get a letter from attorney if they can approve my child's age is locked
in writing. I'm struggling how to ask for my lawyer. How can I do it?
One of two. May as well get the rest of it here.
Is it something that you guys can do? Well, we absolutely can do it. And we're not advertising here. I mean, obviously, we're for profit, but if you want us to help, we're happy to help you. But any attorney should give you anything in writing.
What do you say?
Can I have a written opinion? I need a written opinion as to whether or not my child age has locked under the Child Status Protection Act and any options I may have. If not, to resolve it.
Yeah.
And how much is the cost to give me a written opinion?
Is there anything you really do to resolve it? I guess there's a little strategy. Avoiding premium processing on your I-140s is the one that comes to mind.
It depends on the facts.
Yeah, that's true.
The facts will give you.
Well, I'm happy I came up with one strategy to.
We attorneys do everything in writing. We cannot continue to just give opinions out there in the air. I mean, you need a letter. You need something in writing, and you will get an opinion from the attorney to say, as of 11/8/2021, based on the current existing laws, your child's status has locked because 1, 2, 3, 4, and your child age is 19 years and 25 days. Right?
Yeah. Yeah.
Yeah.
Somebody can give you
Absolutely,
somebody can put it into can
and
pull the
lay out
data,
the numbers.
lay out the number. Yeah,
And
exactly.
here's the exhibit based on the following facts: 1, 2, 3, 4. Conclusions.
Yeah.
That's what we do. Absolutely.
So somebody had this question, and so employment-based visa recapture from which year? Approximately how many visas to be recaptured? So this was the topic of last week's presentation. So there's this great report from the Cato Institute, which basically I can't remember the name of it, but it's probably if you do a Google search for Cato,
somewhere between 300,000 to 500. So there's an interpretation issue as to whether exactly. So there is a 3 numbers that was thrown out. One on the high end, one on the low end.
Oh, and I found the chart. Here we are.
Can you get lucky and go to? I'm not sure if we can put that.
I don't think I'm in the right browser window to put it live. But
so go ahead and give us the numbers, Brian.
So on the reconciliation bill, basically the mid-range estimate is 225,000 employment-based visas coming back. High range is 416,000 coming back, and there's similar numbers about the same for family members. People ask us a lot about that as well.
So there's a lot of interpretation on exactly how much, and if the Democrats will interpret it, I think it's going to be favorable.
Yeah, well,
and if they pass it, it's going to be all flush out here during this administration. So fingers crossed, right? Wonderful, good.
So looks like we got some more commentary on the reconciliation bill. So
no choice but to encounter a Byrd's rule in the Senate. Well, yes, that's her job, right? That's her job. But I think there's 2 things going on. So we got the parole that they're proposing for the undocumented, and then this. There's really, number one, there is a precedence. Remember, 2005, there was a precedence that they've incorporated a recapture in the budget bill, and it was not objected to by either party, and it did not survive because I think by agreement they have removed it at the last minute, but there was not a controversy. The parliamentarian at that time did not rule it out to be improper. So there is precedence on that in our favor. The question is really, in my opinion, it's not the parliamentarian. The question is, we get some folks in Congress that says, if you don't pass the illegal immigration, we will not approve the legal immigration. They're holding the legal immigration hostage to the illegal immigration. And others who have objections to other aspects of the budget bill that's not related to immigration, that's also holding things up. Ultimately, the budget bill will pass because it has to pass, otherwise the government will shut down next month. So it will pass. But the question becomes in what form and whether or not we can have the legal immigration section 60,002 and 60,003 intact in there. So
there's an interesting follow-up on that previous question. I think the checks has changed from 1992, the recapture date, to 2017. And I was just, as you were talking there, Sam, looking at the published text that's available online. I'm still seeing 1992, but this is the Build Back Better drill at congress.gov.
Well, remember I emailed you one, Brian, that was dated 3 days ago.
I'll have to look that up while we're chatting.
Yeah, here. As we're chatting. So let's go through the next question, and I'll let Brian do a little bit of research for us here as we talk.
Yeah. So let me see here. Here we are.
All right. So we need.
I need the question first.
Yeah.
So if the I-140 is filed and pending, and if the dates are current with filing dates, can AOS still be filed, or shall we wait until the I-140 gets approved?
Oh, the I-140, you can go ahead and do it. So if the I-140 is pending, you can absolutely file the I-485 and not wait. So there's no requirement for an approved I-140 for an I-45, because an I-45 it could be filed concurrently, so there's absolutely not a problem there. And Brian is right there on the adjustment status. So, and he is looking at the law. But moving it to 1997 from 2002.
To 19, yeah, well, yeah, 60,003 to.
So go ahead.
Oh, I was looking at the wrong section. Excuse me.
Well,
diversity visas. Let me see here. I was looking at the wrong. Let me go back to 60,002.
Well, let's get the next question here as you look.
Yes.
So
yeah. We don't want to bore everybody with my Googling.
Yeah. Exactly.
So here we are.
Today I received a courtesy letter from medicals from EB3. Brian, can you finish reading it?
Today I received a courtesy letter from medicals.
Can you scroll up and down?
Yeah. I'm sorry. Okay. I don't need to. Today I received a courtesy letter from medicals. My EB3 priority date is retrogressed July 2012. Does this mean the officer started processing my case? Can I send my wife and kids medicals?
The answer is it does mean that the USCIS is looking now at your case for processing without a question. And instead of issuing an RFE and delaying it, they want the medical to be sent right away. And absolutely send your family medicals as well and alert them that these cases should be included in the adjudication of your case, and ask the officer to please pull your family files and adjudicate them at the same time, because it only takes 80 minutes to adjudicate one case, so you might as well do the whole family together. Brian, next question.
So I got to say, I'm looking at the employment-based. I'm still seeing 1992.
Okay, good. So and we will confirm it after that.
Yeah.
All right.
Yeah. So next question. So pending I-45 with approved I-140 on EB3 as of today, can we duplicate EB2 I-45 today?
Pending I-45 with approved I-140 on EB3 as of today. Can we file
a duplicate EB2 I-45? So the question.
You can file a I mean, when you say duplicate.
Sam, I'm gonna say I'm gonna give an uncharacteristically easy answer for me. If you're in status.
Pending I-45 with approved I-140 on EB3 today, can we file? I'm concerned about the word duplicate.
We're talking about a second I-45.
But it's not a duplicate.
It's not a duplicate. It's a second I-45.
Okay, can I file it today? If in status, and if you're current in EB2.
Yeah.
If EB2 is current right now, absolutely, and your I-140 is your I-140 and EB2 I-140. So if
you got to have an EB2,
you have to have an EB2 I-140.
Yeah.
Or you can file an EB2 I-140 if the PERM supports that. Then you can, and if you're in status, then you can absolutely file a second adjustment status under EB2.
I made all sorts of assumptions, but I stick by my uncharacteristically short answer for Brian.
Okay, good. So we're gonna look into this. I mean, changing it to 2007, I think the whole world would have blown up if we haven't heard anything like that. But I would look and see whether that has changed, because
I was just looking. I don't.
But it could be. You know, there's all kind of Twitter releases the last minute, and then they tweet it, and then they change their mind, and then they put it and they take it off. So
they are trying to get to something that they can pass right now, and that would stink. I would hate it. But that could be something that's on somebody's negotiating plate.
But again, it all depends on what language. I mean, changing a date only may or may not solve the problem. So I'll be interested to see that. But thanks for sharing.
Yeah.
And will confirm it and keep you guys up to date.
Yeah. So we actually already addressed this question.
Okay.
Well, you should see some subscribers increase today. Well, that sounds good. Bing, I'm going to move on to the next one.
All right.
Hi, Sam and Brian. Thanks for your service. Expecting EAD AP. Can I start a business? Hey, I like this question already. Can I start a business with EAD and still continue my day job? Sam?
Yes.
Yes, I agree. When I switch to EAD, what to inform the employer to switch from H-1B?
You need to give him the EAD card and say you need to update your I-9 record because I have taken a job. I'm doing some things on the outside, so I'm not technically no longer on H-1B.
Yeah.
Now
that's a great way to put it. Yeah.
Yeah. But now it's very critical for you before you do that to anticipate whether or not you need to file an adjustment status under a EB2, for example. Like let's say you file an EB3 and you're planning on filing an EB2, jumping out of H-1B. Obviously limits that option within 180 days. So you need to ask yourself, am I going to need an EB2 adjustment status soon? Do I file the EB2 adjustment status before I do that? Which would be a smart thing to do. And by the way, there was a new release by ALA, American Immigration Lawyer Association, about
I'm a
interfiling.
member. Yeah.
About interfiling.
Yeah.
So they came out and said it may be better, because a lot of people say, a second adjustment status, not a good idea, it's not a good idea. Now we have the largest immigration attorneys organization in the country saying that filing a second adjustment status may be advantageous.
Yeah.
Officially. That was released last week, which is something that we have been talking about for the last years, right?
Yeah.
And also, did they say flip-flopping interfiling is not a good idea?
Their position on interflopping is interfiling was
Interflopping filing. No?
It's complicated. I'll leave it at that. But while Sam, we'll go back to our brief beef with interfiling. No receipt notices, no checks cashed, and no clue as to what they're doing with it.
And discretionary.
Discretionary.
And obviously,
adjustments is discretionary, but at least you get feedback when you file that second adjustment.
Well, the discretion under the adjustment status is a completely different.
It is guided by regulations, and they can't violate those. Yeah. So
perfect.
Yeah, that's a good question.
But yes, you can work and get update the I-9 for the employer. It'd be nice to send an email to cover yourself. And good luck.
Yeah, I mean, yeah. Oops, skip one. There we are.
So we have stopped the construction in the suite next door because they were drilling, and we told them 7 o'clock Eastern Daytime sharp, you can start drilling again.
Yeah.
So we have a few more minutes before we call it. So before those guys start drilling.
Yeah, construction in the suite next door. Yeah.
OPT is going to be expired.
Oh boy.
Okay. Approved I-140, pending I-45, pending I-31, I-77 biometrics is done. Wonderful. What's the question?
No. I think the problem is pending I-31, I-131, and I-765. What should I? And here's the end of it. What should I do next? Just wait. I'm in the USA. So basically, I think the problem we're seeing here is my OPT is expiring. I can't get employment authorization in time. Well, your OPT is expiring. STEM OPT, you might have a problem with that if you.
I'm assuming he has no more OPT.
No more OPT time.
Well, you're going to have to probably take a leave of absence, but be aware that if you work by mistake beyond your time, but less than 180 days, you may be able to take advantage of INA 245K. We don't recommend that you do that.
Yeah.
You should wait, because that is your safety blanket, if you will, or safety net, if you will, not rely on it.
Yeah, I have heard in some cases, expedited processing is an option for there. You can put in an expedite request with USCIS. Expedite request. We did a whole presentation on these things, and it's hard to get an expedite request. And just not having a job, not being able to work, is not a great grounds for an expedite request. However, I have heard anecdotal evidence of people, saying, I can't have any other employment authorization. My status is expiring. I need this green card EAD to be approved. I have heard of people occasionally getting that successful expedition of green card EADs for that reason.
Sure.
So
yes,
it might be worth considering.
Absolutely.
So
good answer.
Yeah.
Good answer, Brian.
Well, thank you.
All right, 2 more minutes before those tigers start drilling.
So got my green card a month back.
Oh.
I'll clap for that. I'll clap for that. What are you doing, bragging?
Like you're not going to see any issue. Well, how long have you been working for that employer becomes a critical question. If you've been working with this employer for a few months, I would have a concern. If you've been working for this employer for more than a year, I would have less concern.
Well, yeah, I mean, got my green card a month back.
But see, under Supplement J law,
you
can transfer to a new employer after 180 days of filing the adjustment. So why would, when you get the green card, you cannot do that?
Because taking that green card, I mean, I'll give you an alternative. You're right. Basically, you can change Supplement J. You can change it any time. Why can't you do it immediately after you get a green card? Taking that green card is, pursuant to Supplement J or your original I-140 filing, is saying, I intend to be permanently employed, indefinitely employed by this company, and you convinced you got USCIS to give you that green card, and as soon as they give them that green card, out the door.
Like I said, it all depends on how long you've been working for that employer. So if you're working for that employer for a few months, I would be concerned. But if you've been working for the employer for a long time, over a year, I wouldn't be concerned.
So these scenarios are fact sensitive.
Now, in support of Brian's position, it is better not to do something like that if you can help it. But
if you can help it,
let's assume the employer says, "I don't have work for you next month." I've had a guy that lost his job the day after he got his green card, but it wasn't his choice, and he's fine. And also, furthermore, if you move to a different employer in the same or similar job occupation, and there's a challenge in the future, just proving that you moved to another employer doing the same work, I think also a good defense for you.
Yeah.
Because it's within this. But let's assume you stopped and you did completely different. You would started a business completely unrelated. Then that would be a little bit of concern, especially after a short period of employment. So it's fact-driven. More than 1 year and you're doing the same business, I think you're okay. Your employer is letting you go, I think you're okay. Short period of employment.
I mean, I'm gonna be like you right now. I'm gonna have beef with the standard because this person, I'm gonna guess, has been waiting a long time to get a green card, and they've had a stranglehold on their it's been a stranglehold on their life, and now they get it, and then now we're a bunch of lawyers saying you can't really do it.
I have no problem with you leaving, going to another company that does same or similar job that you were doing, and you've been working for this employer for more than 1 year.
Yeah,
that's basically the scenario where I'm comfortable.
Yeah.
When you start squeezing those dates more, then you're entering the zone of uncomfortable zone with me.
Yeah.
In terms of defending it in the future, if we have to defend it.
Well, I think, what are the odds of having to defend that in the future, Sam?
It's reasonable because when you get naturalized for citizenship, they may look at these things.
That is really.
But let's assume you naturalize 10 years later, they're not going to look into it. But you naturalize immediately 5 years, and they look at your employment history and say, "Oh, you worked for your green card for 1 month, and you left," then that could be a problem. But that's the only potential scenario I see it, from my experience. All right, so we have hit beyond the time. We'll take one more question.
Let's do a scroll towards the end here and pick a random one.
Okay.
See what we get.
All right, so Brian, read it.
EB3 downgrade approved from current employer. What to look for before joining an early stage startup with respect to the PERM process? Does USCIS treat employers with 5 workers the same as large employers?
What to look for? An early stage startup with respect to PERM process. Well, the short answer is no. They don't treat them the same.
No, they don't. We have Sam, that are clients that are multinational. You look at their tax returns. They say they did $1 billion in business, and they can get away, not get away, but they don't have to document their cases as well as a smaller employer.
And a lot of time, a startup really are not ready to do a green card because the balance sheet is not in good shape.
Yeah, you're touching on the ability to pay requirement.
Yeah, and if they have more debt than they have assets, and your green card may not work. So the very first thing I would do with a startup is to look at whether or not their finances are in place to support a labor certification.
Yeah, I mean, what should that? I mean, that startup. I would bet out of those 5 workers, they don't have an immigration expert amongst them. I think that startup. So a PERM is an employer-centric process. That employer needs to talk to an immigration attorney and say, "I have a small company. I want to hire a foreign national."
So how is that related to EB3 downgrade? So his adjustment is filed. So if his adjustment is filed and he's doing a supplement J only. But why would he do it for does USCIS treat employer 5 workers same as large employers? Stage startup with respect to PERM process. Why are you doing PERM again if his EB3 downgrade is approved?
Well, it doesn't say there's a pending adjustment of a status. Somebody might
EB3 downgrade approved.
Some people have been known to file EB3 downgrades to.
That's an additional status.
No, people have been known to. I mean, when people saw, when people know that EB3 is ahead,
just the I-140.
Just the I-140, because I want to have it. So we're not hearing about a pending green card. So you're right. So if there's a pending green card, 180 days passed, supplement J, and you can join that 5 employee.
Not a big deal.
You can get asked about the viability of their offering permanent employment, whether they can,
Harry, you need to give us more details.
will concede that.
Yes, but if it's only a supplement J question and you have an adjustment, I don't have a problem. But if you're down and you've indicated a labor certification, so you're starting at start, definitely with a startup is a problem.
Yeah.
With that, we end today's presentation.
We do.
Thank you so much. We're going to keep an eye on the bill for you guys, and let's see if we can get that champagne open next week sometime.
I'll have some champagne. I'll put on a party hat for that occasion.
Take care, guys. Have a good evening. Thanks.